Welcome back to my channel. Today we're going to be talking about qualified immunity. So, qualified immunity is a legal doctrine in the United States that shields government officials from liability for actions performed as part of their job unless they have violated a clearly established federal law or constitutional right. All right, where does this doctrine of qualified immunity come from? The Constitution? No, it doesn't. We're going to have to look to the Civil Rights Act, United States Code Section 1983, to find the language where this qualified immunity comes from. All right, so here's Section 1983, the Civil Rights Act. Any citizen of the United States or any other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. So that's the language from Section 1983. And did you see the language about qualified immunity? Yeah, I didn't either. It's because it's not there. It's not in there. The doctrine of qualified immunity was created by the United States Supreme Court in 1967. And our current test for qualified immunity actually comes from a case from 1982. United States Supreme Court case, Harlow v. Fitzgerald. And this is the language that we have as the current test. Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So the key language in there was clearly established. And what that does is basically adds in some additional language into this Section 1983. So basically, if you look at this section of 1983, this stuff coming from the constitutional laws, it's adding this language that it's got to be clearly established, right? Your constitutional rights could be violated, and there still might be no liability if the law wasn't clearly established beforehand. Now, what does this clearly established mean? Well, that means that there needs to be some other federal case on point with facts that are very similar to the current facts. And sometimes it almost looks like they have to be identical almost for them to say that it was clearly established. So we have several cases, for examples, of where police officers were given qualified immunity because there wasn't any clearly established law that they were violating. All right. I think the last one is the most fun, so let's just talk about some of the others first. So one of the cases in this area of qualified immunity where we have kind of an odd result is there was a prior case where police had sicked a dog on a suspect who was laying down, and a court had decided, okay, that's unconstitutional, that was wrong. Well, there was a later case where someone was sitting with their hands up and the police sicked their dogs on him. And they filed a lawsuit about that, asking for liability. And the court said, no, the police get qualified immunity on this because there was no clearly established law that was violated. Even though the other one was almost the same thing except for the person was laying down instead of sitting up with their hands up. So that's super close, a super close fact pattern, but they still said, no, that doesn't fit. So we don't have a clearly established law that was violated. So there was no liability, and the police had qualified immunity in that particular case. So there was another case where some police were performing a warrant, a search, and they ended up stealing like over $250,000 worth of property. So a lawsuit was filed asking for liability, and the court said, no, they have qualified immunity, there's no liability for this. And this was out of the Ninth Circuit, and the Ninth Circuit actually said, at the time of the incident, there was no clearly established law holding that officers violate the 4th or 14th Amendment when they steal property that is seized pursuant to a warrant. That just seems pretty odd, right? They were stealing, but yet, because of the way this qualified immunity doctrine reads, they said, well, there's no clearly established law because I guess we don't have another case where the police stole that much money as part of executing a warrant. So that's another weird one. But I think one of the funnest cases, there was this 13-year-old kid in middle school PE class, and he was fake burping, like burp, like that. Well, the teacher was getting irritated. I think she sent him to the hallway, and he kept leaning in and kept doing these fake burps, right? Burp. So she got mad. She got the school police officer to come down, who cuffed him and arrested this 13-year-old kid for fake burping. They must have really hated this kid. Like, seriously, to arrest him for fake burping, cuff him, put him in, take him downtown, take his prints. What did he do? It was fake burping. What? Now, the mom actually sued some school officials and the policeman, saying that was totally unreasonable. She sued them, claiming her son had been subject to an unlawful arrest and excessive force. Well, the district court said, no, the school officials and policemen have qualified immunity on this because there was no clearly established law that had been violated. And this went up to the 10th Circuit, and the 10th Circuit agreed and said, yep, school officials, police officer have qualified immunity. There's no liability for this. It wasn't too much to arrest this 13-year-old kid for fake burping. So, my question is, if there would have been another case where there was a 13-year-old kid who was burping for real, would that have been close enough that there was a clearly established law that was violated if that was a fact pattern? I don't know. You guys, so it is 2020, and the United States Supreme Court has 8 qualified immunity cases asking to be reviewed, all right? 8 of them, right? So surely okay, so maybe we have 7 left. They decided not to do, so we still have 6. That's fine, right? We'll still have, are you kidding me? The U.S. Supreme Court decided not to hear any of them. So, okay, we'll wait till next time. So hopefully they'll review one of the next qualified immunity cases. Thank you so much for watching. I hope you learned something. Please like, comment, subscribe, tell your friends, and we will see you next week. What did this police officer say to this kid? Really, like, you are under arrest for fake burping in class. Oh. So gross. See, I feel like those, unless that's what the kid was doing.
Probably.
But would you arrest me for doing that?
No, that's funny.
I just don't think that would happen. So just imagine a 13-year-old kid doing that in gym class. It's gym class. Come on, it's gym class. Just let him, just keep playing basketball. Who cares? Oh my word. I feel like a chip off the old block.